Hello everyone and welcome to this FIDIC session. I hope wherever you are safe and healthy. This is my third session that I am holding in connection with Clause 20 entitled Claims and Disputes Arbitration, the provisions of which are incorporated in Yellow Book, edition first and published in 1999. However, before I review the outstanding subclauses, I would like to underline a few points. First, I have provided an overview of all the FIDIC publications, and there are titles of construction contracts, edition, and other useful information therein, and this has been uploaded in YouTube. Transcripts of all the sessions have been provided and will be sent upon the request free of charge. Third, if you have any questions on these subclauses or in other books of FIDIC, I'll be glad to respond. Now I would like to present to you the summary of Session 1 and Session 2. In Session 1, I said if the contractor encounters with any problems or obstacles which considers himself to be entitled for additional payment or extension of time of completion, then shall send a notice of 28 days to the engineer and employer. If the engineer's decision is not acceptable to the contractor, then the dispute will be sent to a dispute adjudication board. In second session, I explained exhaustively the dispute adjudication board and its provisions. In fact, dispute adjudication board is two types: ad hoc and standing or full. As for the ad hoc, whenever a dispute arises between the employer and the contractor, they will be summoned to come to site and settle the dispute. However, the standing or full term, and they stay at the site for longer period, maybe for 1 year or 2 years, or from the beginning up to the completion of the project. Of course, there is another type, is dispute review board, or DRB, which is mostly used in the United States, and it's advisory, and it's not binding or final, in contrast to ad hoc and standing. Now going back to subclause 20.6 entitled Arbitration, the dispute shall be finally settled by the rules of arbitration and in accordance with the International Chamber of Commerce. If the parties cannot settle their dispute, and in fact the decisions of the DAP has not become final, then for final settlement they have to refer to international arbitration. Unless otherwise agreed by parties, the following conditions shall apply. Dispute shall be settled by 3 arbitrators and in accordance with these rules. C. The language of arbitration will be in accordance with subclause 1.4 entitled Law and Language. The arbitrators shall have full authority to review and revise any determination, opinion, instruction, and valuation of the engineer and decisions of the DAP relevant to the dispute. Whenever the arbitrators need the engineer should act as a witness and be present in the meetings held in arbitration office. Of course, it is clear that the contractor and also the employer they shall cooperate with arbitrators according to rules of arbitration. Every arbitration entity has its own rules of arbitration. So there should not. The arbitration may start before or after completion of works. The obligations of the engineer, the dispute adjudicators, and the employer as well as the contractor will not alter as a result of arbitration. Of course, it is clear that the contractor and also the employer they shall cooperate with arbitrators according to rules of arbitration. Every arbitration entity has its own rules of arbitration. So there shouldn't be limitation to the evidence and arguments that the parties have had before the DAB. Subclause 20.7 entitled Failure to Comply with DAB's Decision. In the event that A. Neither party gives notice of dissatisfaction within the period stated under subclause 20.4. B. The DAB's decision becomes final and binding. C. A party fails to comply with DAB's decision, then the other party refer the failure to the arbitration, and subclause 20.4 and 20.5 shall not apply. Subclause 20.8. If a dispute arises between the parties in connection with or arising out of the contract or execution of works, and the DAB does not exist, whether by reason of expiry of their appointment or otherwise, the two conditions apply. The dispute may directly refer to arbitration, and subclause 20.4 and 20.5 shall not apply. So we wrap up the clause 20, and for the next meeting I will review the DAB's agreement. So have a nice time, and thank you for your time.